ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರಿ? ಹೌ ಡಿಡ್ ಯು ಅರೆಸ್ಟ್ ಹಿಮ್? ಯಾರು ನಿಮ್ ಸುಪೀರಿಯರ್ಸ್ ಹೇಳಿದ್ರ ಅರೆಸ್ಟ್ ಮಾಡಕ್ಕೆ? ದಿ ಪೊಲೀಸ್ ಇಸ್ ಇಂಟರ್ಫಿಯರಿಂಗ್ ನಾವ್ ಇನ್ ಸಿವಿಲ್ ಕೇಸ್. 27 ಮುಂದೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬನ್ನಿ ಅಂದ್ರೆ 25ಕ್ಕೆ ಹೆಂಗ್ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರಿ? ವಾಟ್ ಎವರ್ ಸೂಟ್ ಸರ್, ಇಟ್ ಇಸ್ ಫಾರ್ ದೆಮ್ ಟು ಡಿಸೈಡ್ ವಿಲ್ ಕರೆಕ್ಟ್ ಇಲ್ವಾ ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. ವೈ ಪೊಲೀಸ್ ವಾಂಟ್ಸ್ ಟು ಇಂಟರ್ಫಿಯರ್ ಇನ್ ದಿಸ್? Why I am asking this is not he is a scapegoat. Somebody else is controlling him. I will direct departmental inquiry against the entire station. Our ಏನೇ ಆಗಿರಬಹುದು, he may be the worst of criminal. I am not that. Once you set the procedure in motion and by issuing a notice under 35(3), you have no business to arrest unless he displays non-cooperation. ಕಾನೂನು ಗೊತ್ತೋ ಇಲ್ವೋ ನಿಮ್ಗೆ? ಕಾನೂನು ಗೊತ್ತಿಲ್ಲದೆ ಏನ್ ಕಾಪಾಡ್ತಾ ಇದ್ರೆ ಕಾನೂನು? ನೀವಲ್ಲಿ ಯಾರೋ ಇಬ್ರು ಹೊಡೆದಾಡ್ತಾ ಇದಾರೆ ಪ್ರಾಪರ್ಟಿಗೆ ವಿಲ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ಪೊಲೀಸ್ ನೋಡ್ದಿದ್ದು ವಿಲ್ ಮೇಲೆ ಡೌಟ್ ನಮ್ಗೆ ಅಂತ ಇವ್ರು ಯಾರು ಹೇಳಕ್ಕೆ? ಸಿವಿಲ್ ಕೋರ್ಟ್ ಪೆಂಡಿಂಗ್ ಇಲ್ವಾ? ದಿ ಲಿಬರ್ಟಿ ಆಫ್ ಅ ಸಿಟಿಸನ್ ಫಾರ್ ಗ್ರಾಂಟೆಡ್ ಅಂಡ್ ಟೇಕಿಂಗ್ ಹಿಮ್ ಇನ್ ಟು ಕಸ್ಟಡಿ, ದಿ ಎಂಟೈರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ is equally responsible. Is there any semblance of fairness in police action in this? Action of the investigating officer is on the face of it in blatant violation of the law laid down by the apex court in police. The investigating officer who is present before the court and has no answer as to why he was taken into custody. The investigating officer is now mulcted with cost of rupees 5 laksha, 10 laksha from his salary. Sir, accused number 2 is a witness to the said instrument, the will. Therefore, there could not have the petitioner. Wait.
Please, Maharaj.
Yes. Who is the investigating officer?
He is present.
You are released now?
Yes.
You are released?
It was produced before the magistrate, passed over, and then I've been released.
From there, yes. You were never taken into judicial regular as it is a custody. Yes.
Taken into police custody.
That's all.
arrested.
Anyway, yes.
One submission, before your lordship starts, one submission.
Yes, sir.
Mistake has happened, my lord. My officer should
No,
not.
no, sir. If mistake has happened, they better well pay for that mistake. No, I have been seeing this pattern of this policeman that they take anyone into custody without any rhyme or reason, straight away.
No, I can't.
This should stop.
Yes, ma'am.
Stop forthwith.
Yes,
And how do you stop it? There should be some deterrence. How we give some deterrence? You message ಹೋಗ್ಬೇಕು ಅಂದ್ಬಿಟ್ಟು ಇವ್ರನ್ನೆಲ್ಲ ಒಳಗಾಕ್ಸಲ್ವಾ?
No, I'm not just, for a.
ನೋ, SPP ಅವರೇ, ಇಲ್ಲಿವರೆಗೂ ನೀವು ಹೇಳಿದ್ರಿ ಅಂತ ನಾನು ಇಲ್ಲಿವರೆಗೂ ಸುಮ್ಮನೆ ಇದ್ದೆ, ಏನು ಮಾಡಿದೆ. But this has become too much. Only because of you I had kept quiet till now.
I'm not justifying, my lord. I'm not justifying for a moment. I'm not justifying. Only one mistake. What happened, my lord? Probably, my lord.
Notice ಯಾಕೆ ಕೊಟ್ರು?
No, probably, my lord, young officer has succumbed to it. That notice, issuance of notice is not needed.
All right.
He has issued a notice, my lord.
All right.
The senior officers are probably.
ಆಯ್ತು, why did he arrest once he had issued a notice?
So that is,
Who told him to arrest?
no, but is
No,
confusion.
is there any instructions from any superior to arrest?
It is in.
ಬನ್ರಿ ಈ ಕಡೆ ಸ್ವಲ್ಪ. ಏನ್ ನಿಮ್ಮ ಹೆಸರು? ಸುನಿಲ್ ಕುಮಾರ್. ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರಿ? How did you arrest him? And why did you arrest him? Why? ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರೋ ಇಲ್ವೋ? 35(3) ಅಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟ ಮೇಲೆ 27 ಮುಂದೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬನ್ನಿ ಅಂದ್ರೆ 25ಕ್ಕೆ ಹೆಂಗ್ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರಿ? 35(3) ನೋಟಿಸ್ ಕೊಟ್ಟ ಮೇಲೆ ನಾವು ಕೋಆಪರೇಟ್ ಮಾಡದೆ ಹೋದ್ರೆ ಮಾತ್ರ ಅರೆಸ್ಟ್ ಮಾಡಬೇಕು. ನೋಟಿಸ್ ಕೊಟ್ಟ ಮೇಲೆ ಹೌ ಡಿಡ್ ಯು ಅರೆಸ್ಟ್ ಹಿಮ್? ಹೌ ಅಂಡ್ ವೈ ಡಿಡ್ ಯು ಅರೆಸ್ಟ್ ಹಿಮ್? ಯಾರು ನಿಮ್ ಸುಪೀರಿಯರ್ಸ್ ಹೇಳಿದ್ರ ಅರೆಸ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ರ? ಯಾರು ಹೇಳಿದ್ರು? Were there instructions from any of your superiors to arrest? If you have succumbed to pressure, whose pressure? ಯಾರ್ ಪ್ರೆಷರ್ ಹೇಳಿ? ಎಲ್ಲರ ಮೇಲೂ ಮಾಡೋಣ ಈಗ. Why did you arrest? ನಿಮ್ ಜೋಕ್ ಅರೆಸ್ಟ್ ಮಾಡೋದು, ಅರೆಸ್ಟ್ ಮಾಡಿ ಪೊಲೀಸ್ ಕಸ್ಟಡಿಗೆ ತಗೊಳ್ಳೋದು, ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿಗೆ. ಆ ಕೋರ್ಟು ಅಷ್ಟೇ, ಏನು ವಿತೌಟ್ ಎನಿ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ನೀವು ಕೇಳಿದ ತಕ್ಷಣ ಕಳಿಸ್ತಾ ಇರ್ತಾರೆ. What do you all think? ಅವ್ರು ಏನೇ ಆಗಿರ್ಬೋದು, he may be the worst of criminal. I am not that. Once you set the procedure in motion and by issuing a notice under 35(3), you have no business to arrest unless he displays non-cooperation. ಕಾನೂನು ಗೊತ್ತೋ ಇಲ್ವೋ ನಿಮ್ಗೆ? ಕಾನೂನು ಗೊತ್ತಿಲ್ಲದೆ ಏನ್ ಕಾಪಾಡ್ತಾ ಇದ್ರೆ ಕಾನೂನು ನೀವಲ್ಲಿ? ಇದೆ ಈ ತರ. ಯಾರೋ ಹೇಳಿದ್ರು ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್ ಕಂಪ್ಲೇನೆಂಟ್ ಅರೆಸ್ಟ್. No, this has to be taken note of. Allah, let the superiors also share the cost that I impose now,
Your Lordship,
apart from departmental inquiry.
no, that's probably, my lord, that the young officer has committed a mistake, my lord, but
He's committed a mistake, he has to pay for it. It is taking someone into custody, it's question of liberty.
that's correct, my lord.
He may be worst of criminal, procedure set in motion ಆದ್ಮೇಲೆ ಮುಗೀತು. You can't do that. I am not saying he is, whoever he has arrested is a paragon of virtue, no.
No, no, so everybody is saying that he should not have issued a notice. Even superior
Allah, he
officer
should
has
not have andre.
issued a notice. That is a mistake, my lord. I don't know why.
Incantation like this will not help, sir, unless there is cost imposed. I have already indicated that I am going to
Your
impose
Lordship has
costs.
indicated, your lordship is indicated, my lord, but
2026 2 ACC ಕೊಡಿ ಸತ್ಯೇಂದ್ರ ಕುಮಾರ್ until. Latest
Not carried the judgment. Carried.
and Nalla Balu.
some
No, no, sir,
leniency.
nothing. It's high time that, yeah, who is the, you are in ACP ನಲ್ಲಿ? ಅಲ್ಲ,
ACP and DC is the,
inspector,
is the sub inspector.
sub inspector. He is the IO. ACP ಯಾರು?
Reena Suvarna.
Reena Suvarna.
DCP ಯಾರು?
Saidul Atawat.
What are they doing?
I'll
They will
keep-
also face the brunt now.
I'll keep them present. my
If
lord.
this man is arresting someone without rhyme or reason, what is the ACP doing? What is the DCP doing?
No, I'll keep them present, my lord.
Not necessary. I will impose cost, let everybody take the costs.
No, I'll
I will
keep them
direct
present.
departmental inquiry against the entire station who has indulged in this now.
No, I'll keep them present, my lord.
Not necessary, sir. Not necessary. They will be watching anyway. Station ಹಾಕೊಂಡು ಕೂತಿರ್ತಾರೆ ಏನಾಗ್ತಾ ಇದೆ ಅಂತ. ಅಷ್ಟು ಗೊತ್ತಿಲ್ವಾ ನಂಗೆ? ಇವ್ರನ್ನ ಅಲ್ಲಿ ಕಳಿಸ್ಬಿಟ್ಟು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿರೋದು ಅವರು ಅರೆಸ್ಟ್ ಮಾಡಕ್ಕೆ, ಅಲ್ಲಿ ಹಾಕೊಂಡು ನೋಡ್ತಾ ಇರ್ತಾರೆ ಏನಾಗ್ತಾ ಇದೆ ಇವ್ರಿಗೆ. ಅದಕ್ಕೆ ಗೊತ್ತಾಗ್ಲಿ ಅವ್ರಿಗೂನು. Whoever is the DCP and the ACP, let them also know.
I'll keep them present.
No, sir, not necessary. ಹೇಳಿ ಮೇಡಮ್, ಸಮೃದ್ಧಿ ಬರಕ್ಕೆ ಹೇಳಿ. ಜಡ್ಮೆಂಟ್. The petitioner is what are you? What's the allegation now?
Now that your lordships have asked this question, my only allegation against me is that I'm a signatory to a will, which they claim is a forged will.
Who is the signatory?
I am the
To a
petitioner.
will?
Signatory.
As
to
a witness or
as a
what?
Witness. I am only a signatory and a witness to a will. Lord, there's
Who
a
is the complainant?
there is a civil dispute between the Baligas and the Gopal. So Baligas, Lord, have filed a suit in which they have obtained interim order protecting their possession. Now the will is left by Baliga's grandmother to Vishal Baliga. I am a attesting witness to that will.
The attesting witness is now taken into custody?
Yes, A1 is not taken into custody. A2 is taken into custody. There is an order of injunction and a direction to the SHO to implement police protection orders by this court.
Against whom?
Not against the complainant. Against the complainant here is interfering with my possession. I file a suit.
ಅಲ್ಲ, your possession ಅಂದ್ರೆ A1's possession.
Vishal Baliga's possession. Vishal Baliga has filed a suit for injunction to protect his possession. In that, an IA is filed to protect his possession, allowed, contested all the way to Supreme Court. Now possession is confirmed in favor of Vishal Baliga.
Yeah, who is behind the complainant
The
now?
IA3 Lord is to direct the police to implement the order. Not complied, comes in GM police. There is a direction. Contempt charges are being framed next week, not for 17 for framing of charges in this officer.
Your lordship, since your lordship asked me, the will was notarized.
ಆಗ್ಲಿ,
by a
ಅವ್ರು
person.
ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಕೊಂತಾರೆ ಬಿಡಿ, ವಿಟ್ನೆಸ್ ತಾನೆ ಇವರು.
No, that is the my lord, that the present petitioner. he
And
has-
what do you do about the other proceedings that are pending which go to the Supreme Court and get confirmed?
Your lordship,
Are they playing with them?
Your lordship, is a will.
Ah,
It's
so?
supposed to have notarized by the
The
person.
civil
Not
court will
necessary.
decide.
It was not even notary on
The
that time.
civil court will decide that, not the civil.
It is pending before the civil court?
From 24.
Who are the police to interfere in all this?
Pending before civil court is injunction suit.
Whatever suits, sir, it is for them to decide, will correct or will want ಮಾಡ್ಕೊಳ್ಳಿ. Why police wants to interfere in this?
Injunction.
Why I am asking this is not, he is a scapegoat. Somebody else is controlling him. Somebody else is controlling him. Somebody else has directed him to arrest this man. Civil suit ಅಲ್ಲಿ ಏನ್ ನೀವು, what is the police doing here? If a will, he is a witness to the will ಯಾವಾಗ execute ಆಗಿರೋದು?
In 95, in the
Ah,
wills
then?
of 95, they are.
Whatever it is, sir, if the police saying will is forged now, civil suit pending ilva?
No, and that time, this person could not have done.
Arey, that's a different thing, sir. Civil court will pending ide, they will decide. Why the police is interfering now in a civil case?
No, the pending before civil court is only injunction suit.
Arey, tomorrow they may amend it, sir.
No, my lord, I have to file an injunction suit. Complainant will have to file a.
That is the complainant's case actually, then he let him file.
He is claiming that the will is forged. He has to file a declaration.
Came to know about the existence.
Who
of
came to know, sir?
The complainant, according to us, my lord, came to know about the existence of.
No
will.
problem.
In
Has he
the-
filed a suit, sir?
24 suit, now they came to know.
No, when he
Suit is
filed-
being contested. Why is the police interfering in a will case?
And I am only the attesting witness to. a will.
That's the next thing. Why the police is interfering in a case between two persons which are, who are contesting over a will? ಏನ್ ಇವ್ರಿಗೆ ಶೇರ್ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ? ಪೊಲೀಸ್ನವ್ರಿಗೆ ಶೇರ್ ಇದೆಯಾ? ಅಫಿಷಿಯಲ್ ಇರಲ್ಲ, ಅದು ಬೇರೆ. Then why do they interfere? If the police do not, if police are not stopped from entering from civil cases, this is what is happening. ಯಾರೋ ಇಬ್ರು ಹೊಡೆದಾಡ್ತಾ ಇದಾರೆ ಪ್ರಾಪರ್ಟಿಗೆ ವಿಲ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ಪೊಲೀಸ್ನವ್ರದ್ದು. ವಿಲ್ ಮೇಲೆ ಡೌಟ್ ನಮ್ಗೆ ಅಂತ ಇವ್ರು ಯಾರು ಹೇಳಕ್ಕೆ ಅಂತ? ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇಲ್ವಾ?
No, but this purpose, my lord, the very.
No,
fact
whatever purpose, sir,
that- the very
it does
fact-
not stop at that, takes him into custody. How? That's why I said there is lawlessness here. Stop this police raj. We will have to stop it by iron hands. ಏನೋ ಇರ್ಲಿ ಅಂತ ಬಿಟ್ರೆ ಏನೋ ಅಲ್ಲಿ ಇಲ್ಲಿ ಒಳ್ಳೆ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅಂತ ಇದು ಮಾಡೋದು ಮಧ್ಯದಲ್ಲಿ.
Not if your lordship did not protect us, we would have necessarily gone into custody. 15 days
Definitely, because the
JC
court will not see anything. The moment they give
So
give a
many-
remand application, remand.
Remand
No,
process
the
so
whole
mechanical.
problem with the magistracy today is a remand is made on a demand by the police.
Yes.
Straight away, ಒಂದು ಕೊಟ್ಟ ತಕ್ಷಣ ರಿಮಾಂಡ್.
Please.
ಅದು ಕೇಸ್ ಇದೆಯಾ ಇಲ್ವಾ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಏನು 69 ನೋಡ್ತಾ ಇಲ್ವಾ ನಾವು?
They don't see,
10 ವರ್ಷ ರಿಲೇಶನ್ಶಿಪ್ 69 inside prison.
they don't see,
Huh?
they don't see.
That's a court, sir. They have to see. Actually, they have to see and set things right. Only if there is necessity police custody, they should give. Every case police custody.
And remand application if they
That is
want
why
to-
there is no end to these people. ಎಲ್ಲದಕ್ಕೂ police custody ಹೆಂಗೂ ಕೊಡ್ತಾರೆ ನಮ್ಗೆ?
And they don't even ask for police custody, they ask for JC, so which means he was never required for investigation, custodial interrogation ಬೇಕೇ ಇರ್ಲಿಲ್ಲ. It's a documentary events, what is the.
Whatever
use of
it
taking
is,
into
if you are a
custody
witness and a witness is treated like this,
without the actual person who is said to have
No,
executed the
the-
will.
Our testimony is not.
ಆಯ್ತು sir,
clearly wit- he is
ಒಂದ್
not
ನಿಮಿಷ.
clearly witness.
Accused number 1,
Beneficiary of the. will.
beneficiary of the will, you leave him.
Huh.
Accused number 2, witness to that will, you take him into custody. Is there any semblance of fairness in police action in this?
Kill and-
Any semblance of fairness? ಕೋರ್ಟ್ಸ್ ಇಲ್ಲ ಅಂದಿದ್ರೆ ನೀವು ಮುಗಿಸ್ಬಿಡ್ತಾ ಇದ್ರಿ. ಎಸ್, ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. The petitioner is before the court. Only arrest or you challenge everything?
We've challenged everything. FIR.
The petitioner is before the court calling in question registration of a crime in crime number 586 of 2026 for offences punishable under section 61, 338 and 340 within bracket 2 of the BNS 2023. What drove the petitioner to this court was the police taking the accused number 2, a witness to a particular will which is pending adjudication before a competent civil court, into custody. A crime comes to be registered in crime number 586 of 2026 for the aforequoted offences. The petitioner is drawn as accused number 2. The jurisdictional police, i.e. the Whitefield subdivision police, issue a notice to the petitioner under section 35(3). Where do I get that?
Annexure B, page 19.
One moment.
And that notice is not given prior to arrest not. First time taken up from a house, station al kodtar signature madu.
The notice given on 25/8/2026 reads as follows. The notice directs the petitioner accused number 2 to appear before the Whitefield Police Station for the purpose of investigation at 11 a.m. on bold element 27/8/2026, 2 days after the issuance of notice. This is the unequivocal chain in the notice. The police pick up the petitioner from his house by arresting him 2 days prior to the date on which he was directed to appear. The 35(3) notice is also said to have been issued by the police at the house of the petitioner at the time when he was taken into custody. Be that submission as it is, but the notice itself indicated that the petitioner was to appear before the Whitefield Police Station on 27/8/2026 at 11 a.m. but is taken into custody 48 hours even before his appearance, even before the time that he was asked to appear. It is trite law that once the police set the procedural law into motion by issuance of a notice under section 35(3), the arrest of a person or the noticee can be only if the said person would display non-cooperation with the investigation. It is only then he can be taken into custody if a notice is issued under 35(3) and he is directed to appear and on his appearance would not cooperate with the investigation. That time had yet to arrive, as it was 48 hours time for the petitioner to appear before the police and cooperate with the investigation. The petitioner is then taken into custody in the morning of 25/8/2026, produced before the learned magistrate at about 3 p.m. It is then the matter was moved to be taken up immediately, as the arrest was on the face of it illegal. This court passed the following order on 25/8/2026. The petitioner was not then remanded to judicial custody, but was set free by the concerned court owing to the interim order granted by this court. Nonetheless, the petitioner was arrested and was produced before the learned magistrate for the purpose of remand to the judicial custody or otherwise. It is the submission of the learned counsel for the petitioner Angat Kamath stands to reason for all the nuances of an arrest is followed by the respondent, and while he was produced before the magistrate for an order of seeking remand to judicial custody by filing a remand application. Remand application hakidra?
I've been told, my lord, he was taken to magistrate, but not produced before magistrate based on this order.
Based on the order. Anyway,
ಮಾಡಿದ್ದಾರೆ.
remand application. Arrest ಅಂತೂ ಮಾಡಿದಾರಲ್ಲ.
Affidavit
Yes. So and so. The action of the investigating officer is on the face of it in blatant violation of the law laid down by the apex court in Satyendra Kumar Entil 2026 2 SCC page 162, where the apex court holds as follows. The apex court holds that once the procedural law is set into motion by issuance of a notice under 35(3) or 41A of the CRPC, the statutory predecessor of the BNSS, the only circumstance that one can be taken into custody is on display of a non-cooperation by the accused. The time was yet to arrive, but the liberty of the petitioner was taken away by his arrest by the police, the investigating officer who is present before the court and has no answer as to why he was taken into custody, whether he was pressurized by his official superiors or otherwise, there is no answer to any query of this court as to why the procedure as stipulated in law by the judgment of the apex court supra was not even noticed by the investigating officer or his superiors in the said police station. It is not only the investigating officer who would be responsible for this atrocious act on their part of taking the liberty of a citizen for granted and taking him into custody. The entire police station is equally responsible. The officer in charge of the police station or the superiors who man the police station, the assistant commissioner of police or the deputy commissioner of police, who have just led the investigating officer to behave in a manner that is blatantly contrary to law. They are equally responsible on their supervisory dereliction. The learned SPP, though, would put up vehement defense on in an aid to protect the investigating officer who has on the face of it fumbled in law by arresting a person who could not have been taken into custody once the notice was already issued. Therefore, it is not a case where this court would show hands off to such attitude of the investigating officer, but mulcted the investigating officer with exemplary costs, apart from a direction to initiate departmental inquiry against the investigating officer and the official superiors who have permitted the investigating officer for their dereliction of supervisory roles. Therefore, the arrest of the petitioner, which on the face of it is illegal, is declared as such, and the investigating officer is now mulcted with cost of rupees 5 laksha, 10 laksha from his salary, sir. Not from his pocket, it has to go, not from the state exchequer. The cost of such illegal arrest is quantified at 3 lakhs to be paid by the investigating officer, by the official superiors who have shown dereliction of supervisory duty upon the investigating officer. The amount of cost that is to be paid to the petitioner shall not be from the state exchequer, as it is public money. Since the investigating officer has acted contrary to law, the cost shall be paid from his pocket, or the cost shall be paid from the pockets of those who man the police station, i.e. the Whitefield police station. The learned, diving back to the merit of the matter, the learned counsel for the petitioner, but in 2 ದಿನ ಆಗಿದೆಯಲ್ಲ crime.
Sorry, ma'am.
Crime register ಆಗಿ 2 ದಿನ ಆಗಿದೆ.
ಇಲ್ಲ 10/8, not 10th
10/8.
10/8. FIR is on 10/8.
Diving back to the facts of the case, it is an admitted fact that the petitioner is a witness to the will that is the subject matter of a suit that is instituted by the complainant before the civil court in the year 2024 in OS.
Instituted
by the complainant.
By the accused number 1 in this.
Accused number 1. By the accused number 1 in OS.
1708 of 2024.
1708 of 2024.
Before the second
Even before the said institution, a suit for injunction is pending between the parties in OS.
1708 of 2024.
Injunction suit ಯಾವುದು?
ಅದೇ injunction suit. That is the injunction suit.
ಈಗ ಹಾಕಿಲ್ಲ 24 ಅಲ್ಲಿ.
24.
Old suit ಯಾವುದು?
There is 95 suit, OS number 10195 of 1995. There's a partition suit.
The suit of the year 2024 is a rehash or an offshoot of the suit of the year 2000.
1995.
Of 1995. Be that as it may, the issue is on the face of it purely civil in nature. The petitioner, admittedly the role of the petitioner is that of a witness in a will. The will is before the civil court or otherwise. It is not a matter for the police to interfere now unless criminality is projected. What is the allegation against the accused number 1 is the offense punishable under section 61, 338 and 340 within bracket 2 of the IPC. This straight away is attributable to accused number 1. Accused number 2 is a witness to the said instrument, the will. Therefore, there could not have the petitioner, much less an arrest, the very investigation against the petitioner. And it is settled principle of law that a witness to an instrument cannot be hauled for investigation even by plethora of judgments rendered by this court following the judgment of the apex court. In that light, there shall be an interim order of stay of further investigation qua the petitioner only, accused number 2. It is made clear the interim order would not become applicable to accused number 1. Adannu hakidira iga?
Yes, ma'am. No,
Will
I
not
have
become
not-
applicable to accused number 1.
A separate petition
Yes.
filed by A1.
First maybe.
No, no, sir.
Huh?
Costs and departmental inquiry eradu.